There are 10 families that brought this lawsuit against the Ten Commandments law, and half of them are self-proclaimed atheists, secular humanists, agnostics, or otherwise non-religious individuals. And the judge in this opinion often mixes defending his ruling based on free exercise of religion and free exercise of moralism or spirituality, kind of whatever these other belief systems are. The reality of the First Amendment is that it protects religion. It doesn't protect non-religion. This broader concept of what is religion under the First Amendment is really important in this case and a few others we've recently discussed. Is it, as the founders understood, is religion the worship of the Creator, or is it this kind of fuzzy sentimentalism that turns ourselves into our own gods?
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofit organizations. This week we'll be covering a district court's permanent injunction against the Ten Commandments law in Arkansas, which potentially sets up a pretty significant split on these types of laws. Then we'll go to Chicago and talk about a win for religious schools in the Chicago Public School District. And we'll finish up with a case in Oklahoma that could do what St. Isidore could not and pave the way for religious charter schools to exist in the state of Oklahoma and also move First Amendment precedent forward. So lots to get into. Let's start with this first case. So Arkansas, this is really interesting. This is a Ten Commandments in the classroom case, which we just recently covered, a similar type of law that was upheld in the Fifth Circuit. Now we have the opposite ruling from a district court in Arkansas. So the laws are really similar. This is very similar to the Fifth Circuit case that we talked about. Arkansas passed a law called Act 573, which requires all public school classrooms to display the Ten Commandments. Again, similar to the Louisiana law that we talked about recently in the Fifth Circuit case. Arkansas is in the Eighth Circuit, so this is a different circuit, and the Fifth Circuit precedent does not control here. But I think it's interesting still because the Fifth Circuit rejected exactly the argument that the district court in Arkansas adopted. So we're going to get into what's going on here. I just want to talk about a few areas of the court's reasoning that I think are really problematic in this case in particular. And then, Joseph, I think you have a little bit to say about the greater First Amendment issues at play here. So a couple things. First of all, you need to make clear the law does not require teachers to teach the Ten Commandments. This is only a display in the class. The judge in the Arkansas District Court, the opinion states that nothing, quote, could possibly justify hanging the Ten Commandments, end quote, in school classrooms, and that there is, quote, no need to strain our minds to imagine a constitutional display mandated by Act 573, end quote. So the implication here is that pretty much any display would be unconstitutional, and you would need to bend your mind to think of a version of a display of the Ten Commandments that would be constitutional. This is mind-boggling. I'll get to that. So the judge's reasoning is that, I shouldn't laugh at a federal judge's opinion, but the only reason one would display the Ten Commandments is to proselytize children, and that this effectively establishes a state-supported Christianity at the expense of other faiths. I have so much to say here. This is completely unreasonable. But I want to make three quick points that I think are all worth pointing out, especially because I think that this argument is going to make its way up the courts very soon. So first of all, come on. There are clearly reasons other than proselytizing children to hang the Ten Commandments in classrooms. You want to assume the best of everyone, but it's very hard to find a serious argument here. I mean, the Ten Commandments have long hung in American courtrooms and other government institutions because the Ten Commandments are at the foundation of the legal tradition, not just of America, but of most of the Western world. Right? So you could possibly say that proselytizing children is one reason to display the Ten Commandments, although even that I have issues with. I'll get to that in a minute, whether that's proselytizing at all. But to say that proselytizing children is the only reason to hang the Ten Commandments, that's frankly absurd. I could imagine, to switch the example, right, culturally, I could certainly imagine like a patriotic Chinese regime requiring the posting of like the sayings of Confucius in schools for a reason other than trying to proselytize children to become Confucian, because the work of Confucius has deeply influenced Chinese law, government, culture for centuries, right? So we're posting something that comes from a religious tradition, equating to we are proselytizing people to become that religion. Just, it doesn't work. The same thing applies here. This is just a wild leap to say that this is the only reason you would hang something that has so much legal and historical significance besides the religious import. Secondly, the idea that posting the Ten Commandments is state-supported Christianity strikes me as less than convincing, because the Jewish religion is founded on the law and the Ten Commandments. Muslims, I looked this up to make sure, also revere the Ten Commandments as divine law given by God to Moses. So yeah, there are differences in interpretation and translation, right? Different forms of the commandments, different ways that they're phrased and split up between Catholics, Protestants, and Jews, sure. But to say that the posting of the Ten Commandments is a state-supported Christianity is kind of ridiculous, because it's not an exclusively Christian symbol. Plus, as I've said many times before on this podcast and elsewhere, state-sponsored establishment problems are about supporting one church or one denomination. So like, this isn't the imposition of a Baptist or a Catholic symbol to the exclusion of other denominations. Generically Christian but non-denominational symbols or acts, like the display of the Ten Commandments in a classroom, doesn't violate a traditional and sane understanding of the Establishment Clause, right? I know this is repetitive for people who listen to this regularly, but 19th century public schools, they read from the King James Bible, they recited the Our Father. Again, it's not establishing a religion, because it's not a church, right? Christianity is a broad swath of religious beliefs, and they all hold the Ten Commandments in common, as do the Jews and to an extent the Muslims. And so to say that this is state-sponsored Christianity is wrong. To say that this is a violation of the Establishment Clause is even more wrong. Last point, the idea that this is proselytizing is kind of embarrassing. I mean, teachers aren't being asked to explain to children why the Ten Commandments are true, why the children should become Christians. Teachers aren't required to teach the Ten Commandments at all under this law. So simply hanging the Ten Commandments, it's just not proselytism. Right? That's not an effort to force children to accept the teaching of the Ten Commandments. It's not even forcing children to read them. They're just hanging there. The idea that this is like coercive or proselytizing, to me, is just kind of silly. We've seen this before in like these cases where people allege that like the presence of a cross at a churchyard, a memorial, right, a public memorial for veterans or things like that this is coercive or, religious proselytizing. These are silly. I'm not going to get into like the case law and the background behind this, but it just, this is like it's a very odd thing to me that you could take what is proselytizing is like aggressively trying to convert people to your faith. Posting the Ten Commandments, besides the fact that they are not just, a proselytizing type of religious document, it's just a poster hanging there. Like, if that's really offending you and making you feel like someone's trying to convert you to their religion, that's on you. That's just objectively not coercive. I could keep going on here, but those are the main things that I wanted to point out. I expect that this case is going to go up to the Eighth Circuit pretty soon. I don't know how. Depends on the panel they draw, but I think it would be kind of interesting if we see the Fifth Circuit come back with a merits decision on the actual constitutionality of that law in Louisiana, and if we see this go up. Like, these are starting to get popular in various red states, these Ten Commandment laws, so I wouldn't be surprised if we see a circuit split in the next couple of years, and I think this is probably something that the Supreme Court may weigh in on in the next couple of terms.
Yeah, Frank, thanks for explaining what's going on there. And like you said, this could be, obviously it's in kind of the early stages of this percolation, but it could eventually kind of work its way up. And there's just two things that I want to add to point out here, really, on the broader First Amendment jurisprudence. And the first ties back to something we discussed recently in that Indiana RFRA case, where basically a judge ruled that having an abortion available to you is a religious right under RFRA. And that's a wild statement. If you want to learn more about what that means, just listen to that episode, because it really is mind-boggling. But there's a somewhat similar concept at work in this case here. So there are 10 families that brought this lawsuit against the Ten Commandments law. And half of them are self-proclaimed atheists, secular humanists, agnostics, or otherwise non-religious individuals. And the judge in this opinion often mixes defending his ruling based on free exercise of religion and free exercise of moralism or spirituality, kind of whatever these other belief systems are. And regardless of how sincerely or deeply held they are, the reality of the First Amendment is that it protects religion. It doesn't protect non-religion. And I want to be charitable to this opinion. There is an Establishment Clause thing that you also, I think, rightly debunked. So it's not all the free exercise things. And Frank, you addressed the free exercise claims as well. But I did want to point out that this broader concept of what is religion under the First Amendment is really important in this case and a few others we've recently discussed. Is it, as the founders understood, is religion the worship of the Creator, or is it this kind of fuzzy sentimentalism that turns ourselves into our own gods? That's eventually, if this is a case that works up, is something that could end up before the Supreme Court and could be really important. And second, I want to mention the Lemon Test. Now, for anyone unfamiliar, the Lemon Test was a Supreme Court case from 1971, basically set a test for determining if a government activity is an unconstitutional establishment of religion. There are three prongs to the test, all centered around, is there a secular purpose to the government activity? Is the primary effect of the government activity to advance or inhibit religion? And does the challenged government activity excessively entangle the government with religion? And the kind of three-pronged Lemon Test also evolved into a reasonable observer test, basically asking, would a reasonable observer consider the challenged activity an endorsement of religion? Now, the problems with Lemon became pretty clear not too long after it was made law. And part of the issue is that it's very unclear and essentially led judges to rely on personal intuitions rather than actual law. And in 2022, the Supreme Court made clear that they agreed with this assessment of Lemon in a case called Kennedy v. Bremerton, which is a like prayer in public school. Basically, a coach would pray after games at a public school, and someone filed a lawsuit against him, and he ultimately won. The coach did, who prayed. But there in Kennedy, the court explained that, quote, the shortcomings associated with this ambitious, abstract, and ahistorical approach to the Establishment Clause became so apparent that this court long ago abandoned Lemon and its endorsement test offshoot. So the Supreme Court recently finally said Lemon's gone. It's persona non grata here in the courts. As our listeners might know, Justice Scalia famously described the Lemon Test as a light-night ghoul that, although it's been killed and buried several times, often shambles out of its grave to haunt school children. And for myself, being on the younger side, when I first encountered Scalia's words, I thought they were funny and probably true, but I didn't really get the weight of it. I've mostly been in the Kennedy world where Lemon Test has been explicitly disavowed. But in the last few months especially, I've really grasped and felt the weight of Scalia's assessment a lot more. Even though we have this Kennedy ruling from a few years ago that expressly declared Lemon disavowed, courts keep leaning on the logic of Lemon. Last week with Matthew Hoffman, I discussed a free speech public school case where basically a public school censored a pro-life student, and the judge in that case ruled in favor of the public school, again, leaning on a case that was built out of the Lemon Test. And we're seeing the same thing in this case here. The judge here in this case explains that Stone v. Graham, which is a case from 1980 that looks pretty much the same to this, it's the same kind of facts pattern, controls. But the issue is that Stone was predicated on the Lemon Test. There would not be the same, I don't know what the ruling would be in Stone, but it certainly wouldn't be the same logic in Stone if we did not have Lemon. So that Stone ruling used Lemon to rule that posting the Ten Commandments is an Establishment Clause violation. So just bringing this together, despite being in an explicitly post-Lemon era, the test continues to stalk our courtrooms, and I'm hopeful that we're able to drive another pencil through the heart of the ghoul if this continues to keep going. So Frank, that's what I'm saying. Before we continue, is there anything you'd want to add? Awesome, great. Glad I got my Lemon jurisprudence right. So
yeah, you're good. Sorry, I was on mute, but yes, I have nothing to add. Lemon is in fact dead, keeps coming back. It's always worth reminding everyone of that imagery. How like at least pieces of it keep coming back, which is very mysterious. But hopefully this can be another nail or stake, as it were, in the coffin.
Yep, excellent. So with that, next we'll discuss our next update, which is a settlement in a lawsuit over Chicago Public Schools' denial of a Christian college from its student-teacher program. So the facts are pretty straightforward. There's this college in Chicago called the Moody Bible Institute of Chicago. It's a Christian Protestant college. It requires all of its staff to be Christian. Every employee at the college is expected to maintain an active Christian faith and be prepared to discuss it with people both internal and external to the college when asked. So really that Christian identity is prevalent. Top to bottom, it's really in everything. One of the degrees that the Moody Bible Institute offers is a bachelor's in elementary education, and the college requires those students to receive in-classroom experience to graduate. So students getting this bachelor's degree have to have teaching hours in public schools and in Christian schools. It's interesting actually that they require both. So Chicago Public Schools, CPS, not Child Protective Services, but CPS, Chicago Public Schools, has a student-teacher program that fits really exactly what Moody requires of its students. And CPS is a huge educational system. There's over 600 schools with over 325,000 students and about 23,000 teachers employed throughout the CPS schools. And the student-teacher program partners with about 50 different colleges, both public and private, to produce about 1,000 student teachers. So there's about 23,000 teachers in the system. About 1,000 additional are student teachers doing exactly what Moody kind of requires their students to do. And it's also worth noting that despite an $8 billion budget, that's a billion with a B, CPS is unable to fill hundreds of open teaching jobs. There's certainly a need for more staff in these schools. So back in the kind of facts of this case, Moody initially received permission to have its students participate in this student-teacher program at Chicago Public Schools. However, they were eventually denied the ability to send their students into the program because of Moody's religious beliefs and their practice of hiring co-religionists. CPS demanded that Moody College drop its requirements that its staff follow the Christian faith. And in order to participate in this student-teacher program, the college had to sign 2 agreements stating that they will not, quote-unquote, in CPS's words, discriminate in hiring based on religion. So Moody College sued and recently settled with Chicago Public Schools favorable to Moody. As a result of the settlement, the college students can participate in the student-teacher program without the college losing its right to hire based on religion. So legally, because this is a settlement, we can't really get into the court's reasoning, but there are a few couple key points from this case that I think kind of go beyond just the facts here. And for one, in this case, the quote-unquote non-discrimination requirements were not enforced across the board. There were other Christian colleges that also preferred co-religionists in hiring that were able to participate in the student-teacher program with no issues. So if this case went through litigation, it would likely, that fact would probably trigger strict scrutiny even under the Smith framework, right? If it's a neutral and generally applicable law, there's no strict scrutiny, but as the court also ruled in Fulton, when there's this individualized exemptions or the rule doesn't apply across the board, it's strict scrutiny even under Smith. And even kind of adding on to this point, something that was really strange from the complaint that they filed was that CPS itself actively prefers some races over others in their own hiring practices, and they advertise this fact. So they're throwing this fit against this Christian college for saying we want to hire Christians, but then they turn around and say we're going to favor people of a particular race, and we're going to advertise that fact. So that's kind of the first point, even if this non-discrimination requirement doesn't apply across the board, so therefore if it did litigate, it would probably still be strict scrutiny. And second, even if the non-discrimination requirements were applied in all instances, I think you can make the case that this still is a likely violation of free exercise, where we have this Trinity Lutheran, Espinoza, Carson v. Mason line of cases that establishes that the government cannot condition a publicly available benefit solely based on religion. Moody was denied access to this state program only because of its religious identity and practice, and the First Amendment prohibits that. So again, we didn't actually get to hear from the court on this, but I think that argument could certainly be made. And additionally, even kind of putting those things aside, church autonomy and the ministerial exception protect the right of religious organizations to hire according to their beliefs. So we've seen a lot about church autonomy and ministerial exception in the last month or two, really. And generally speaking, under these doctrines, a religious organization or church has the legal right to prefer co-religionists when hiring ministers, and possibly in all roles if some logic from the Ninth Circuit gets expanded elsewhere. But under the ministerial exception, a religious organization can hire or fire a minister really for any reason. And that's relevant because what Moody is doing in this case is completely legally protected, and then this government agency comes in and says you actually can't vindicate your own rights in order to participate in our program. And kind of a side note, Moody College does a great job of trying to make all its staff fall under the legal definition of a minister. There's no one clear definition with the current jurisprudence of what a minister is for the ministerial exception. Generally, the test is that the person has to perform vital religious duties. And Moody does a great job of trying to make everyone perform religious duties. They say everyone has to pray, everyone has to be willing to and ready to explain their beliefs to internal and external audiences. Everyone's expected to maintain a Christian lifestyle. So just kind of for broader employment practices for a religious organization, they do a good job of trying to make everyone fit under this ministerial exception and thus give them more leeway to hire according to religious beliefs. And the last point that I want to bring up is that Illinois actually has a Religious Freedom Restoration Act, a RFRA. And this is the law, for anyone unfamiliar, that states that whenever the government does something to substantially burden religious free exercise, that activity is subject to strict scrutiny, which more often than not the government activity will fail to satisfy. As our listeners might know, but some might be newer to this, there's a federal RFRA, but it was eventually invalidated as applied to the states. So since the late 90s, a bunch of states have passed some version of their own RFRA. and Illinois is among them. So while CPS doesn't actually apply this non-discrimination requirement equally and is targeting the legally protected rights of some religious organizations, even if this law was neutral and generally applied across the board, Illinois state law would invalidate the public schools requirement because it's a substantial burden on religious exercise, and if it were to go to litigation, it'd probably be under strict scrutiny. So bringing it all together, I think ultimately that it was a good decision for Chicago public schools to settle here because it's pretty clear that their behavior was unconstitutional, illegal, and against the common good. As I mentioned at the start, there are hundreds of open positions in Chicago public schools, despite their astronomical budget. And barring qualified applications because the organization that they come from acts on its legal rights makes no sense. It's a pattern we've seen before. Trying to cut out religious groups from spaces that we need them simply hurts the people that need them, that need help the most. So, Frank, that's some of what I'm seeing, and I'd love to hear your thoughts as well.
Yeah, just one point here. So I think this is an interesting problem to untangle because there are a lot of moving parts. This is a common theme now, this exclusion, not on the basis of religion, but being a certain kind of religion that discriminates, in violation of some of these secular non-discrimination laws. So it's not the same as applying a non-discrimination law without religious exemption, right? Like in a human rights law, because the government isn't saying you cannot discriminate or else you're going to be punished. It's just saying, well, if you discriminate, you might have a religious exemption to do that, but then you can't participate in this program, right? But then we get to this Carson problem where it's like, well, you're excluding religious organizations from generally available programming because of their religious beliefs, right? But then the response is these kind of two steps where they're like, oh, hold on. We're not discriminating and excluding you from this program because you're religious. We know we can't do that under Carson. It's discrimination that you're engaging in, not your religion. It's your discrimination that's the problem. But the interesting thing is the conclusion then is only certain kinds of religious organizations, right? Those that don't discriminate are allowed into these programs. And then this kind of looks to me like the problem that was dealt with last year in the Wisconsin Catholic Charities case, right? Because then what you have these programs saying is, well, no, we can't. We're not saying no religious orgs, period. We're only saying the kind of organization that won't hire LGBT people or won't hire non-Catholics. Only those groups are excluded. And then it feels a little bit like that establishment of religion issue that Justice Sotomayor came in and said, okay, so some religious orgs or some religions, but not others are allowed only if they do this, but not that. Then I think you do have, I don't know if you'd call it an establishment clause problem in that case, but there are church autonomy concerns for sure. So like I said, you can just, in the last 2 minutes of me trying to untangle this myself, you have like free exercise Carson problems, you have like establishment problems, you have church autonomy and ministerial exception problems. There's a lot going on here. Like you said, this is a case that was settled by a settlement agreement, but there are plenty of these, even like in Maine, right? There's the case Crosspoint versus Macon, where there was similar attempt to, is that the right case? Yeah. Where they're trying to exclude not schools for being religious, but for being the discriminatory kind of religious. So this is a big problem. This is being used by states all over the country to exclude certain religious organizations, even though they know they can't just discriminate against religious orgs writ large after Carson. So somebody's going to have to do something about this. I wouldn't be surprised if this is another one that will end up being a circuit split and a kind of Carson round two in the next couple of years at SCOTUS. Speaking of round two at SCOTUS, let's end with our Oklahoma case here. So there's an organization called the National Ben Gamla Jewish Charter School Foundation. It's a mouthful. So they filed suit against Oklahoma seeking permission to open to get charter status for a faith-based school. Anybody who followed St. Isidore, that led to the disappointing result for us last year in the U.S. Supreme Court, this will sound familiar to you. So as you probably remember, the Oklahoma Supreme Court ruled in St. Isidore versus Drummond that faith-based schools are in fact prohibited from participating in the state's charter program. Now a Jewish foundation is seeking a reversal of this previous opinion from the St. Isidore case. It is asking the court to allow parents to send students to these religious schools and to grant them charter status. One thing that's always worth pointing out here is that not all charter schools look the same. So depending on what state you're from, I know I gave a presentation at a Pennsylvania Federalist Society chapter, and somebody raised their eyebrows and was like, that sounds like an establishment clause issue. Well, in Pennsylvania, charter schools are very much public schools. Like there's very little that distinguishes them legally or funding wise from a public school. So just to note, the Oklahoma system is different. The charter schools they're private schools. They're founded as, a private nonprofit entity. They have a board. They have their own policies, their own everything. And then once they're enacted as a private school, they enter an agreement, like a kind of contract with the state charter school board and get some funding, right? So this, to me, the Oklahoma situation looks a lot more like Carson v. Macon and tuition vouchers than it does like a religious public school. So worth pointing that out because people who are used to a more public school type of charter school are thinking of something different. Anyway, that being said, if you remember in St. Isidore, the state charter board had approved the Catholic charter school. Then the Oklahoma new attorney general was elected who was not on board with this. He sued the charter school board. We had this interesting back and forth where the Oklahoma governor supported the charter school. The Oklahoma attorney general did not. They were on opposite sides of this lawsuit, both Republicans, very interesting political situation. And the attorney general claimed that the charter school status for a religious school violated the state and the federal constitution, as well as their state charter school statutes. So Oklahoma Supreme Court agreed with the attorney general, prohibited the school from opening. This went up to SCOTUS, and everybody, again, will probably remember that Justice Barrett recused herself, and we ended up with a 4-4 non-decision that let the St. Isidore decision at the state Supreme Court level stand. So here we are. This looks like round 2. The case is very new. There's not a lot to say about the facts or if the legal arguments will be any different than St. Isidore, though I doubt it. But as we all remember, so Justice Barrett recused herself from St. Isidore. That it certainly changed the outcome of the case because with the 9th justice, we would have had a precedential ruling. I think we have good reason to believe that Justice Barrett would have been a 5th vote for St. Isidore being permitted under the free exercise clause to get the charter school status. Again, that's only speculation. It is also speculation that it was Justice Barrett's friendship with Nicole Garnett, who was involved in the creation of St. Isidore, that led to the recusal. But again, all speculation. We don't know the reasons for this. What we do know is that a lot of people want to see what I think is actually a pretty mild continuation or just affirmation of Carson v. Macon in this charter school case. That this shouldn't be breaking any really strong new ground. That if Carson v. Macon is right, if it's a violation of the free exercise clause to ban religious schools, just because they're religious from tuition voucher assistance, then to me, this is kind of the same thing. Like the Oklahoma charter school contracts and the funding, that looks a lot like the tuition situation in Maine. I think it kind of follows naturally. At least 4 justices agreed. If Justice Barrett agrees as well, then this case could do what St. Isidore could not. So I am very interested in watching what happens here. I hope to see this case go up quickly to the Supreme Court. I also hope to see no recusals. And I think there's a pretty good chance from the way this is set up that this will be the case that will bring St. Isidore round 2 up. And if people have been following this podcast for a while, we did predict this as soon as the St. Isidore case came out, that there would be a round 2 in a year or two. So less than a year after St. Isidore was released, here we are. My guess is the Supreme Court at the Oklahoma state level will say, we already decided this in St. Isidore. I think this will go up through the state courts and then to SCOTUS petition pretty quickly. So we will be on top of this and keeping you updated. But Joseph, anything you'd like to add before we close here?
Yeah, just one minor detail. Like you said, this is really early stages, and it looks almost like kind of the same thing as St. Isidore, so not a whole lot of new content to add there. But one minor detail I'd like to point out is that I'm hopeful to see this go to the Supreme Court, yes, for maybe to get a potential victory here and a continuation of Carson v. Macon, but also just to hear more of what the justices' thoughts are on this type of thing. The opinion from St. Isidore's was one sentence long, and it basically just said that we're equally divided, so we just affirm the lower court's decision and no precedent there. If we get a 5-4 decision here, we're going to get probably a long opinion, a bunch of concurrences, and a bunch of dissents. So as we're in kind of this unique moment in the religious liberty world, and we're kind of going through a re-examination in some ways, or at least a kind of reordering of some of our establishment clause and free exercise jurisprudence, I'm really curious to see what, if anything, this case changes, if it is just a continuation of the Carson line, if it is kind of a more seismic shift, which I would doubt, but we won't really know until we actually get to see something. So really just, if nothing else, out of the intellectual curiosity of what do the justices think about this type of fact pattern. We didn't get to see that in St. Isidore's, but if this does go up, we'll definitely get to see it. So.
Yeah, no, that's a good point. And I would just point out that Carson v. McEnroe was decided in 2022. So no real, I mean, I'm trying to think who would have been different. It would have been Justice Breyer rather than Justice Jackson, but I think the other 8 would be the same as today. Is that right? Yeah. So it's interesting because Carson was a 6-3 case. So like you said, regardless of the outcome of this case, if we do get around to, I would very much like to see if there's a justice who voted for Carson v. Macon, but against St. Isidore, there had to be, because that's the math, right? If there were if Carson v. Macon was 6-3 and you take away Justice Barrett, you still have 5 votes in favor of Carson, but you only had 4 of those votes in favor of St. Isidore. I would very much like to see why that is. So I'm with you, because I've followed this case since St. Isidore was, freshly filed, and I can't see how you could be for Carson v. Macon and not for St. Isidore. So I agree. I would like some clarity here. And with that, we will just wrap up. And thank you for joining us for another episode of the Napa Legal Podcast. So if you enjoyed the content we're putting out, we always appreciate it if you like the podcast. Subscribe to our channel on YouTube, Spotify, or wherever you're listening from. We now have only, I think, 2.5 more weeks by the time you're listening to this to register for the Napa Legal Good Counselor Project Lawyers Conference, which will take place on April 23rd at the Catholic University of America campus. If you want more information, if you want to see the other events, things that we're doing, content that we're publishing, if you want to support us financially, you can see all of that and do all of that at napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you so much for joining us. God bless you.